Welcome, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and this is the last review session for the February 2026 Florida bar exam. We're going to jump right into things and move along and make sure that we hit all of our bases and prepare you guys for the test that's coming up on Tuesday. So I'm going to start with the essay subjects. First subject is contracts. Contracts, I think, is a very manageable subject. If you see a breach of contract claim, or they're talking about, damages, or, somebody had an offer acceptance, you should already know what you're going to do. My mnemonic that I use is buy friends drinks, big drinks, BFDBD, right? And that stands for body of law, formation, defenses, breach, and damages. Those five things you can talk about on every contracts essay, and you can get a lot of points. And if you remember that buy friends drinks mnemonic, you can consider me your friend and come meet me Wednesday night at American Social and put that into practice. So for body of law, obviously UCC versus common law. UCC for goods, all things movable, and then common law for land or services. Also, when I'm talking about body of law at the beginning of my contracts essay, I like to identify who are the parties, and if they're merchants, what is a merchant and why is that important? And I like to identify what type of contract are we dealing with. Is it an output contract? Is it a requirements contract? Is it an installment contract? Is it divisible contract? Is it a unilateral contract, a bilateral contract? Is it a quasi contract, right? Different types of contracts, and you can, get points for that. It is important to note that this is a requirements contract, which means that the supplier will supply all that the buyer needs for the contract. So at the beginning, you talk about UCC versus common law, identify who are the parties and the significance of them being merchants, and then identify what type of contract are we working with here. Once you've talked about the the body of the contract, the body of law, you'll talk about the formation of the contract, the offer, the acceptance, and the consideration. An offer is a manifestation of an intent to bind another to a contract that gives the power of acceptance in the offeree, and an acceptance is mutual assent to the terms of the contract. There must be a meeting of the minds. So you have the offer, you have the acceptance, and then you have the consideration, a bargain for exchange of mutual detriment or value in Florida. At this point, you could also talk about mirror image test under common law, where the terms of the acceptance need to match the terms of the offer exactly. And you talk about the battle of the forms provision under the UCC, where if there's an additional term in the acceptance, so long as it's not material, it will be included in the contract. If it's material, it'll be knocked out, and UCC gap fillers will apply. So you can really get a lot of points right there for just talking about, has there been proper formation of a contract? Maybe you could talk about the mailbox rule. If letters sent in the mail, where offers are effective upon receipt and acceptances are effective upon dispatch. Maybe you could talk about the firm offer rule, or an options contract where the offer remains open for a certain period of time. But if it's a firm offer, it needs to be by a merchant in writing, and it'll remain open for the stated time or for up to 90 days, right? You can talk about irrevocable offers and revocable offers, different things like that in the formation. So you have the body of law, the UCC versus common law. Then you have the formation, which is the offer, the acceptance, and the consideration. Then you go into the damages section. Always, always statute of frauds, right? And I have two mnemonics for you: my legs and swap. My legs is contracts in contemplation of marriage, contracts that cannot be completed with 1 year, contracts for land, executorships, goods over $500, and suretyships. Then exceptions to the statute of frauds, I use swap, specially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Those two, promissory estoppel and partial performance, often missed by writers on the essay, and it's important. Everything that you mentioned could be important. So statute of frauds is the first defense that you always want to talk about, right? And then after you talk about the statute of frauds, think about other common defenses: mistake, unilateral versus mutual mistake, right? A unilateral mistake is when one party's mistaken, and the mistaken party will have to bear the burden of their mistake unless the non-mistaken party knew of the mistaken party's mistake and essentially took advantage of them. And then mutual mistake, which means there's no meeting of the minds, and this could lead to rescission or reformation of the contract. So you have statute of frauds, mistake, mutual and unilateral mistake, fraud, duress, misrepresentation, right? Very common defenses to contract formation. And then there's a lot of I's and a lot of U's when it comes to defenses to formation and execution. I's like illegality, incapacity, intoxication and infancy, um, inc impossibility, impracticability, illusory, illegality, right? Those are like 7 defenses that start with I, right? For U's, there's like undue influence, unconscionability. Um, those are some major defenses that you could potentially write about. Maybe frustration of purpose could come up, but generally the biggest ones are statute of frauds, mistake, fraud, duress, and misrepresentation, and then impracticability, impossibility, and um, incapacity, right? Intoxication, uh, infancy, or mental infirmity, right? These are different defenses to contract formation, but you're just marching through the essay. Like the issue is whether A could prevail against B for a breach of contract. Before we even get to the breach, we have to talk about the body of law, the contract formation, and the defenses to contract. Then we get to the breach, right? The breach, typically, it's an anticipatory repudiation, an unequivocal demonstration of intent not to honor the obligations of the contract, or it's the perfect tender, or there was a non-conforming shipment, or it could be substantial performance under common law where they didn't substantially perform. There could be arguments both ways. A will argue that B breached the contract. B will argue that A breached the contract. But you want to have that conversation about a breach of contract. Here, you could also think about things like parole evidence. That comes up a lot. Like, were they supposed to do this? Well, it wasn't in the agreement, but they had talked about it. Well, parole evidence will bar extraneous evidence that contradicts the terms of the contract, but it will come in for condition to contract to clarify ambiguous terms or to show a defect information or something of that nature. So parole evidence, something that you should anticipate, right? Like anticipatory repudiation, you should anticipate writing about something like parole evidence. So yeah, you get to the breach of the contract and then you get to the damages. I personally like to write damages first. If I see contract essay and C says what damages could A receive or what remedies are available to A, I like to write that section immediately because um, it's the same every time, right? You're just telling the reader what are all the remedies available. Let me step inside. Someone's car alarm is going off. All right. So, when you're talking about damages and remedies, this is the statement that you can make, and you can write this right away, that there are legal relief and there's equitable relief for breach of contract claims. Legal relief is expectation, consequential, incidental, reliance, restitution, liquidated damages. Equitable relief is court ordered, like specific performance or reformation or rescission or injunctive relief or declaratory relief or some promissory estoppel reliance theory, right? I mean, some of them are kind of crossovers between, they could be equitable, they could be legal, depending if it's monetary or if it's putting an obligation, but generally the main ones are expectation, put a non-breaching party in a position they would be if the contract was performed. There's consequential damages, which are foreseeable, right? They must be foreseeable and therefore lost opportunities. There's incidental damages, which are, as a result of the breach. And always think about mitigation and the duty to mitigate damages, the cost of cover, that conversation comes up here. And then reliance damages, for detrimental reliance, a promissory estoppel theory. Liquidated damages, they're contemplated ahead of time because they'd be too speculative in light of a breach, and they must be reasonable and cannot operate as a penalty. And then restitution to disgorge ill-gotten gains to prevent unjust enrichment. And then for the equitable relief, typically specific performance. If it's art or land, you're going to argue for specific performance as the proper remedy. And then reformation to reform or modify or edit the contract to, represent the intent of the parties. And then rescission. Rescission is putting the parties in the position they would be if the contract was never entered into. So those are, big ticket items for damages. And you can kind of start off and, just introduce to the reader for breach of contract claims, these are the type of damages available, legal and equitable, maybe mention them all, and then start talking about the ones that are truly applicable here. In the alternative, right, expectation damages are proper. In the alternative, they can argue for reliance damages. The liquidated damages clause is important to note that it would likely be unenforceable because it was not reasonable and it called for 50% of the contract price and it would operate as a penalty. Like different, discussions there. But here, you're just kind of getting all your main points down. So you see, just in that framework, body of law, formation, defenses, breach, and damages, there's a lot of points to get. And then some other issues that you should be on the lookout for, like I said, parole evidence, anticipatory repudiation, modifications. If they're going to modify a contract, you typically need consideration at common law, but just good faith of the UCC. An accord and satisfaction, if there's like an agreement to pay off a disputed debt with a new amount, that would be the accord, and the satisfaction would be the payment of that amount. Non-compete agreements, which need to be reasonable in geographic scope and subject matter and duration. Like I said, the firm offer rule, if there's a options contract made by a merchant, it's in writing, then there's no need for consideration and it will remain open for the stated time period or for up to 90 days. The confirmatory memo rule comes up a lot, right? As like an exception to the statute of frauds where they had an oral agreement and then one of the merchants sent a memo that had the essential terms. That also comes up is the essential terms test when you're talking about formation under the UCC. You need to identify the goods and, the quantity, but not the price, right? The price can be determined by reasonable terms. And then, if it's an employment contract, you would need the salary term. That's an essential term. So, those are some big issues when it comes to contracts. It's typically the same, essay every time. But remember, it's not guaranteed that it's only going to be contracts. It could be contracts and property. It could be contracts and torts. It could be contracts and ethics. So, don't just marry the outline, utilize the outline while answering the direct questions being asked and the facts of the essay. But in general, I mean, you should be able to cruise through a contracts essay with the body of law, the formation, the defenses, the breach, and the damages. And, some of the other things that you're going to look for and just kind of throw in there if you can would be like parole evidence, anticipatory repudiation, firm offer, liquidated damages clause, accord and satisfaction, modification. Those are some of the major things that you're going to talk about in contracts. And remember, like I said, identify the parties. Are they merchants or not? Identify the type of contract we're dealing with and if that has any implications on the contract. Some questions from the chat. Are you wanting to put opposing arguments in the body of law? I mean, maybe if it's questionable, debatable, if it's common law versus UCC, or maybe you can use the predominant purpose test, but that's not really something that, there's a heavy opposing argument for. It's really usually pretty obvious that there's one applicable body of law, and that's what we're going to run with. The opposing arguments are usually going to be for the breach or for whether it should have been in writing or not. Those are where you can have more opposing arguments. But just in general, you should be happy to get a contracts essay. You should be able to cruise through it. And remember, there's no reciting rules. Once you've stated a rule once, just write C above for that rule. You're not going to get points again for writing a rule twice. Try to make your essays organized and easily readable, bold, like key terms, underlined, subheadings. Imagine you're writing these essays to be turned into your boss at work and you want him to receive something that's legible and that's well organized and that's highly complete. So that's my advice for contracts. For torts, I mean, torts is about the claims of action and being creative with identifying as many claims of action as possible. So if you have, I give this example. If I step outside of my house and someone throws a rock at me and says IBIS prep sucks, there's a lot of claims of action. one, they're a total liar because I was Prep does not suck. We're a top tier company. But two, there's assault, there's battery, right? They threw the rock, it hit me in the head. That's assault and battery. There's trespass to land, right? Because the rock intruded upon my property. So that's assault, battery, trespass to land. IID and NIED because now I suffered emotional distress every time I walk out of my house. I'm nervous there's going to be a flying rock, right? There's also defamation because they said something about my business. It's actually slander per se because it's about my business, right? So think about all those claims of actions. I was just able to discuss there based on one minor incident, right? Well, depends how hard the rock was thrown and where it hit me, but still, there's a lot of claims of actions where most people they see something like, okay, assault and battery, but they miss the IID, the NID, the defamation, the slander per se, and the trespass. So you kind of want to look at every occurrence from the lens of if I was a personal injury attorney, these are all the claims I would make. And okay, maybe the judge will throw out four of them, but if he allows, two of them, that's good, right? The more alternative theories of recovery you can argue for, the better it is. So don't just write the obvious claim of action, try to write the additional claims of action. Like I said, in contracts, pretty much always you're talking about the statute of frauds. In torts, you're pretty much always talking about negligence. I can't recall a single torts essay where you don't talk about negligence. So you want to write about duty, breach, causation, and damages. Duty, where an ordinarily prudent person, the standard of care that they should be held to in a similarly situated circumstance. A breach is a deviation from that standard of care. And then causation, actual to but for causation, and then proximate, the foreseeable plaintiff or the zone of danger. And then damages. Damages for torts can be lost wages, pain and suffering, medical expenses, loss of consortium. These are the type of things that you want to talk about and just get automatic points for. Things that people miss on torts essays when it comes to negligence would be intervening and superseding events, things that could cut off the chain of liability. On all torts essays, I think it's prudent to mention that Florida is a modified comparative fault state, which means that if any party is over 50% at fault, they'll be barred from recovery. For negligence cases, Florida has abolished joint and several liability, so you can't recover the entire amount from one party. You would have to recover severally from each party. You would have to recover individually from each party, not joint and severally. And then remember that in Florida, punitive damages are limited to 3 times compensatory or $500,000, the greater of the two. Those 3 points I feel like can come on every torts essay. Modified comparative fault, abolish joint and several liability, and the limitation for punitive damages of 3 times compensatory or $500,000. When you're talking about negligence, also think about negligence per se, right? If there's a statute that imposes a duty and it's a designed injury and protected class, or res ipsa loquitur, if the thing speaks for itself, or if there's like an open and obvious right condition, then there would be no duty to warn. In that case, the eggshell plaintiff rule, where you take the plaintiff as you find them and you're responsible for the their damages as they come. Those are just some things that you could think about with negligence. So duty, breach, causation, damages, intervening, superseding, negligence per se, res ipsa loquitur, eggshell plaintiff rule. There's almost always an NIED argument, right? A negligent infliction of emotional distress argument that could come up. And if there's an NIED, right, it's like if you give a mouse a cookie, he's going to want a glass of milk. I don't know if you guys get that reference, but if you have an NIED argument, there's probably going to be an IID argument as well, right? They just kind of come together. There's the one essay that y'all did in practice about like the cookies, and there was NIED and IID because they ate the peanut butter cookies and it was a wedding, and that's crazy. Everyone is emotionally distressed. But there was also an argument for assault and battery there because the kid fell into someone, even though it wasn't purposeful, even though it would fail. You would still write about that assault and battery because there was an offensive touching. So just kind of think about that. Like if something seems like it could be related to a claim, discuss that claim, even if it ends up saying, however, this claim will likely fail because the element of intent was not satisfied, XYZ, right? So you want to get in the habit of just taking stabs at more claims of action and trying to prevail with them if possible. So another thing that's highly tested when it comes to torts essays is the vicarious liability respondeat superior. If you see an employer-employee situation, you might as well argue for that the employer could be liable for the employee's negligence so long as it's within the scope of employment, and differentiate between a frolic and a detour. A detour is considered within the scope of employment and would impose liability, whereas a frolic is outside of the scope of employment and there wouldn't be no liability imposed. So, some key things that you can talk about in torts, really dealing with negligence and trying to remember to write some of those key points. If you learned intervening versus superseding and respondeat superior, vicarious liability, those are points that people might miss that you definitely want to utilize to expand your essays. So then there's the intentional torts, right? Assault, battery, false imprisonment, trespass to land, trespass to chattels, conversion, IIED, intentional interference with a business relationship. Maybe you can even do a malicious prosecution argument, right? Those are the intentional torts where you need the element of intent. And if it seems like it could be relevant, you're better off trying your best to discuss it, and then coming to a conclusion that on balance, the court will likely find that this argument would fail because the element of intent was not satisfied. But you're still better off mentioning it. So we have negligence, and then we have the intentional torts. Then there's these other torts that are highly testable. Premise liability, products liability, and defamation. I feel like that's the big three when it comes to torts, right? And torts that they like to test a lot. So premise liability, you're talking about a duty, breach, causation, damages analysis, invitee, licensee, known trespasser, unknown trespasser, the uh, attractive nuisance doctrine, right? You kind of want to go through that entire discussion and say, the invitee has the highest duty of care as a business guest. They have to make reasonable sweeps of the property, whereas the unknown trespasser, there's really no duty owed except not to intentionally harm them with attack dogs or a spring trap or something like that. Attractive nuisance doctrine means that if a child is lured onto the property with attractive nuisance, the child will be treated like an invitee and not a trespasser based on the reasonableness of the situation and the child's decision. Florida recognizes the dangerous instrumentality doctrine. So if you lend your car to your kid and your kid gets in an accident, then the parent could be liable because it's their dangerous instrumentality which caused the incident. So, it's kind of like a nice little Florida distinction to talk about. So, yeah, definitely premise liability. I like that word, premise liability. I like using the highest legal jargon, don't just say a slip and fall, say a premise liability claim. For products liability, remember this, whenever there's a product that causes injury, there's two totally distinct arguments. There's the negligence argument, and then there's a strict liability argument. Remember that whenever there's a strict liability, products liability argument, there's a contemporaneous argument for negligence. Because imagine you're the attorney and you're arguing this to the judge, and the judge might throw out your strict liability argument, but he might like your negligence argument. Okay, cool. We're just trying to get money for my client here, right? So the negligence argument is duty, breach, causation, damages. They deviate from the standard of care by designing it this way or by failing to include a warning label or whatever it may be. That's a negligence argument. Alternatively, and more prominently, there's a strict liability argument. In Florida, strict liability is for wild animals, inherently dangerous activities, and products liability, right? And then Florida's also abolished the one bite rule for dogs. So if your dog bites someone, you could be held strictly liable for those injuries as well. But for the products liability case, strict liability, there's different theories of strict liability. Design defect, right? It was designed improperly. Manufacturing defect, it was manufactured improperly. Failure to warn or inadequate warning, so express warranties. And then the implied warranties of merchantability and fitness for a particular purpose. So you want to go through each one of them and get your points. So for a design defect, you're thinking about the consumer expectation test or the risk utility balancing test where it wasn't safely designed. For the manufacturing defect, it came off the assembly line wrong, right? It wasn't assembled properly. It wasn't made how it was designed. Express warranties, fair to warn or inadequate warning, maybe inconspicuous warnings, they're too small or they're non-existent. And then the implied warranties of merchantability, that it works properly, it functions. and then fitness for a particular purpose that it works for a particular reason it was warranted to work for. Typically, you can also bring in a misrepresentation claim here, right? A negligent or an intentional misrepresentation claim if they said, yeah, it works for this reason, but it didn't. So you can kind of see with torts, it's not just about picking the obvious argument, it's about writing all of the arguments. If there's an injury from a product, it's a negligence argument, it's a strict liability argument, and it could be a intentional or negligent misrepresentation argument. And you want to make sure you get all those points. And then defamation, they like to test defamation because it's kind of a crossover if you think about it with con law. And they like to cross over. Why is it a crossover with con law? Because it ties into freedom of speech, right? Well, I'm allowed to say XYZ, I have the freedom of speech. Well, no, not really, because not all speech protected the Constitution, and defamation is unprotected speech, right? Defamation, a private versus a public plaintiff, right? A public plaintiff, you need to prove actual malice, whereas a private plaintiff, you just need to prove mere negligence. There's also the media defendant rule in Florida, where if they give notice within 5 days, then the newspaper media publication has 10 days to retract that statement. And then the person can only recover for actual damages, nothing above what they actually incurred, right? There's defining libel versus slander. Slander spoken, libel is written or published. Slander per se, which is a good mnemonic is club, crimes of moral turpitude, loathsome disease, unchastity, and about a person's business. That's when I said in my example with The Rock and they talked about my company, that would be slander per se because it was about my business, right? So, a lot of points you can get with the defamation argument. And then remember, truth is a complete defense to defamation. So make sure that you're really strong with those torts. Defamation, premise liability, prox liability. Make sure you know all the intentional torts, and then make sure you know a good, strong negligence discussion. And just thinking about things that are heavily tested, like I said, superseding and intervening, respondeat superior, res ipsa loquitur, negligence per se. And then the three main points that I mentioned on every essay, that Florida is a modified comparative fault state. They've abolished joint and several liability. And there's a limit from punitive damages of 3 times compensatory or $500,000, the greater of the two. There's other things that you could definitely see on torts. I mean, they could have like a medical malpractice claim, they could have a wrongful death claim, a survivorship claim. These claims could come up and you just want to march through them. But I think torts is pretty easy. Torts is just like, this is the claim of action, this is the rule, and then this is the argument. You don't need to get too creative. The creativity in torts is thinking of more claims of action. Like A could possibly argue for this. It's pretty shitty argument, but I'm going to tell the reader about it. So again, I think torts is my favorite subject. Torts essays, whenever I've taken the bar exam, I've scored the highest on because it's just a reasonable argument. What would a reasonably prudent person do under similarly situated circumstances? And then have that discussion and then talk about the intentional torts and then some of the other torts. Maybe there could be a nuisance, right? A private nuisance or a public nuisance. The difference is that a private nuisance is brought by private party, a public nuisance is brought by, let's say, the attorney general. And then thinking about nuisance, it's got to be disturbing or annoying to a person of ordinary sensitivities, not someone who's abnormally sensitive. Um, Someone's asking the entire rule in bold. I mean, stylistically, I'm not the most stylish person, so I don't know. I don't really know the answer. There's not like a definitive way to do it, but like I would bold maybe battery and then write the rule not in bold. You know what I mean? That's probably how I would do it. But just remember, like they're not grading you on did you comply with the style that we want. It's just maybe you'll get a style point here or there, but the real reason I do it is because the worst essays that I've seen are the ones that are just like one big paragraph. They're just like a run-on discussion. That's really hard for the grader to go through it and be like, oh, they got this point, they got this point, they got that point. But if separate things by subheading and by topic and by issue, rule, analysis, conclusion, it's a lot easier for the reader to give you points. And the way that you write these essays, this is my advice, is like fuck you to the reader. Like, fuck you if you think you're going to fail me. I wrote every single thing possible. I made it super neat and presentable. I gave it to you on a silver platter. You're out of your mind if this isn't a passing essay. I talked about everything there is to talk about, and there's no way you could have missed it. I literally bolded and underlined it for you. You're out of your mind if you think you failed me. That's how I write my essays. Instead of like, oh, I hope I wrote something. No, like I wrote everything. And then I even added on some new things. I think it's important to note that if Tommy was an alien living on planet Endor, he would have this claim. However, the facts do not support this. There's not enough information to know this, so I'm going to move forward. That's how I write my essays. I hit every single thing there is to hit, and then I even am like, I'll talk about this or that too, just in case you wanted me to talk about that. So like you really want to write these robust essays that are well organized, that give the reader every opportunity to give you points possible. If you're when in doubt, write it out, right? That's what I say. When in doubt, write it out because you don't lose points for writing things, but you might miss points for not writing things. And it happens all the time where I'm like, hey, did you write about this? And they're like, ah, fuck, I was gonna write about that, but then I thought it wasn't relevant. It's like, yeah, if you were gonna write about something, at least put it on your paper quickly. Take 2 minutes to say, you know, Tommy could argue for conversion here because the he took the basketball off the shelf. However, that argument would likely fail because he put the basketball right back on the shelf and he never actually converted it. Like there's some things are like obviously poor arguments, but if there's some reason why you might want to include it, then I would try to include it in general. Um, so would it be fair to say for battery, the intent to inflict harmful or offensive contact on the person of another? Yeah, I think that's fair. The intention to uh, inflict offensive touching is fair enough. Remember that not all touchings are battery, and you can have that argument if it's unintentional or if it's a normal touching of everyday life. If you tap Susie on the shoulder and tell her that her bus is there. What effect, if any, does the joint and several liability of Boschman in Florida have on vicarious liability respondent superior? Is the latter an exception to the former? I'm a little fuzzy on that as you go over it. So, um, joint and several liability, think about it's been abolished in negligence cases when there's distinct parties, when there's like a car accident, there's A, B, and C. Well, A cannot collect entirely from B if it's part C, B's fault and part C's fault. Well, you're talking about responding superior. It's not really like a separate party. It's like a vicarious party. So they could be entirely liable. You might want to discuss when you're having that discussion the difference between indemnity and contribution. Contribution is a partial shift of loss, where indemnity is a complete shift of loss. So in that case, I mean, it could be an indemnity situation where the employer is entirely liable. But it wouldn't be the case where there's A is in a car accident with B and C, and you can recover the entire amount from B or C jointly and severally because that's been abolished. Section headings and subheadings are good, right? Yeah, definitely. Section headings, subheadings are good. But again, know yourself. If you're really running out of time, don't waste time making it pretty. Waste time writing issues and rules and analysis. You know what I mean? If you're someone like me who's a really fast writer and a speed reader, then you could take time to you know, uh, make your essay beautiful. But it's really like beautification is not as important as completeness of issue spotting, rule recitation, and analysis. So contracts, torts, when they come up, you are going to knock them out of the park. Just, if there's anything that we mentioned that, you're not strong with, just go over it. You have time and don't like, remember that it's not multiple choice. You don't have to be exactly right. You just need to be in the ballpark and have a discussion. You only have 1 hour to write an essay and you have to read it. How perfect can your response be in terms of accuracy? And the questions are by definition arguable. Some people are going to say that A prevails, some people are going to say that B prevails. It doesn't mean that one person's right or wrong. It matters if you have the discussion. So try to not be so nervous about getting it right or wrong and just be more focused on name dropping, rule dropping, and having the appropriate discussions. For con law in Florida, con law is a tough subject because it can be tested in various ways. Con crim law, con constitutional procedural law, which is kind of like crim pro, and then federal con law, and then Florida con law. In general, I like to start my con law essays with standing, state action, and justiciability, right? Is it right but not moot? Is it a state actor? And is there causation, redressability, and injury in fact, right? Just kind of, orient your reader, like just like I do with the contracts. Who are the parties? What type of contract is it? What body of law is it? Um, with con law, I like to say, well, why is the person who's bringing up the constitutional argument, why are they even allowed to bring up this argument? Because they have standing, because there's state action, and because it is justiciable. In general, they're going to ask you to argue why an act or ordinance or statute is unconstitutional. There's certain ones that come up often, right? Due process, equal protection, vagueness, overbreadth. Those come up a lot, where you can pretty much always argue that in some way it's vague or overbroad or implicates due process or equal protection. Make sure you know the scrutiny levels: strict scrutiny, intermediate scrutiny, and rational basis, and when they apply. Um, First Amendment comes up a lot: freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly, especially the freedom of speech one, where it's content-based, strict scrutiny, or content neutral, time, place, and manner restrictions, which is a heightened intermediate scrutiny. It needs to be narrowly tailored to an important government interest, substantially related, and leave open alternative avenues of communication. That's a time, place, and manner restriction. A content-based restriction is strict scrutiny. It needs to be narrowly tailored to a compelling government interest and necessary to achieve that result, right? And the least restrictive means possible. So that's content-based speech restrictions. So content-based versus content neutral comes up a lot. Anything that is a fundamental right will trigger strict scrutiny. So in Florida, they also add the right to work, right, as a fundamental right, the right to vote, the right to travel. Access to courts comes up a lot, right? You can argue that this somehow is impeding on the access to courts. The Kluger doctrine is mentioned in Florida, that's like a counter argument to something like a fundamental right, like access to courts, to say that there's an overarching public necessity, and that's why they should be able to restrict access to courts in that moment, right? Remember, Florida has a heightened right to privacy because it's expressly stated in the Constitution. These are some good things that come up with Florida con law. Again, you don't really know if it's going to be federal, if it's going to be Florida. If they say only use the Florida Constitution, don't think that means don't write about freedom of speech and freedom of religion and jury trials and all, because Florida has adopted everything in the federal constitution. You have the same rights, the same due process rights, the same equal protection rights, and things like that. A suspect class also includes disability in Florida: race, alienation, national origin, and disability. So, if you're doing the equal protection argument, you should include that. Due process can be substantive or procedural. Procedural is the notice and hearing requirement. Substantive due process means that they're not depriving them of a fundamental right. Um, with con crim, it's usually the Fourth, Fifth, and Sixth Amendment. And just in general, you should know the Fifth Amendment pretty well. Remember, I said the First Amendment is freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly. The Fifth Amendment is due process, the takings clause, the right against self-incrimination, double jeopardy, and the Miranda rights. You should, be able to utilize any of those arguments if they are to come up. Takings, right? There can be a eminent domain procedure where the government is taking private property for public use, and they have to provide full compensation in Florida if there's a governmental taking. So those are some main thoughts about the Fifth Amendment and things like that. For Florida specifically, oh, like I said, the con crim one is Fourth, Fifth, and Sixth Amendment. If it's a con crim essay, it's usually Fourth Amendment, search and seizure, reasonable expectation of privacy, warrant requirements, exceptions to when you need a warrant. I like the spaces mnemonic: search instant to arrest, the plain view doctrine, the automobile exception, consent, exigent circumstances, hot pursuit, and the stop and frisk Terry stop. And then it'll be the exclusionary rule, where anything that is unconstitutionally seized will be excluded, and therefore suppressed. And the fruit of the poisonous tree doctrine, where anything that is discovered as a result of evidence that should have been excluded will also be suppressed as fruit of the poisonous tree. So definitely that argument. And then they go into the Fifth Amendment, and it's usually Miranda rights, where they have to read the Miranda rights to someone before a custodial interrogation. So you want to define custody, define interrogation, and then, recite the Miranda rights. They have the right to remain silent. Anything they say can and will be held against them. They have the right to an attorney, and if they cannot afford one, one will be provided for them. That's that Fifth Amendment right to counsel. Typically, that's what you're talking about on the Fourth, Fifth, and then Sixth Amendment would be the confrontation clause and your right to counsel after adversarial proceedings have begun, after charges have been filed. It's usually, that whole discussion about an invalid search and seizure, or maybe the police will argue that it was a good faith exception, or it was an inevitable discovery, or attenuation, or something like that of that nature that just is a counter argument to that. So, really be on the lookout for that Fourth, Fifth, Sixth Amendment argument and your constitutional rights for con crim. For Florida con law specifically, they like to test the sunshine law, that there's a right of access to all governmental proceedings. So if two or more legislators are having a conversation about, enacting a law or something like that, then that would be a violation of the sunshine law because there's a right to access. I think it's a good counter argument. Well, we didn't violate the sunshine law. We have a heightened right to privacy in Florida, but the sunshine law argument will likely prevail over that argument because, there is that public right to access. So kind of, having these conversations on the paper, A will argue this, B will argue that, A will likely prevail. So there's the sunshine law, then there's the homestead exemption, and that kind of ties into real property as well. You'll see like takings ties into real property. Like I said, First Amendment ties into defamation, which is a tort. So like there's a lot of these crossovers, right? And you just want to address the essay as they come. You could have the first ever, family law contracts ethics essay. You don't know. You don't know what the topic is. So you just want to cover all your bases. And if you see something and it's asked about, just write about it without assuming that you're not supposed to write about it. You're always better off writing about something that's extra than not writing about something that you were supposed to write about. So, the homestead exemption, it protects half an acre inside a municipality and 160 acres outside a municipality. This is your primary residence from judgment creditors. There are certain creditors who can pierce the homestead, and they're usually, people who had an interest in the home itself, like mortgages or construction liens or mechanics liens or homeowners association fees or, property taxes, right? Taxes in general can pierce the homestead exemption. There's enacting a law in Florida, or when how an act becomes law, right? It has to have a single subject, a clear title. It has to be related to the health, welfare, and morals of the people of Florida. It has to have an enacting clause, like be it enacted in the state of Florida. And it has to have a single subject. They definitely test that one a lot, where it's like this act is about curfews and it's about, um, uh, people having their televisions too loud in their house or something, right? Like that would not be a single subject, and you could argue against that. There has to be bicameralism, so it has to be voted on in both houses, and then presentment to the governor. And remember that Florida does not allow for a pocket veto, so he actually has to sign it for it to become a law. And if he doesn't sign it, then it will still become a law because he doesn't pocket veto. It just has to be presented to him. So, there could be special legislative sessions. There could be, some governmental things. I think an issue that people always miss on Florida con law essays is separation of powers, right? That encroachment, entanglement, entwinement, usurpation argument where they're taking a duty from the executive branch and empowering the judicial branch, or they're empowering the legislative branch with the judicial duty or something like that. So kind of look out for that. Definitely chartered versus unchartered counties. Chartered counties have municipalities with home rule power that can enact their own laws and ordinances so long as they do not, they're not preempted by the state government. Whereas general laws or I'm sorry, non-chartered counties have to follow the general laws of the state of Florida. Again, there's general laws, special laws, and general laws of local application. General laws apply uniformly to the state of Florida. Special laws are county-based and are subject to a referendum, a vote by the county. And then general laws of local application are population-based, and therefore they don't need to have a referendum or a vote because they're not based on a special county. They're just based on a population. So make sure you can talk about those things if necessary. Chartered versus unchartered counties, home rule power, and general laws versus special laws versus general laws of local application. Florida has, we talked about the Kluger Doctrine, where it's you can override, let's say, a restriction to access of courts or some other fundamental right if there's a overarching public necessity. And yeah, there's a lot of things that you could potentially talk about on a Florida con law essay, and you don't want to miss it. I mean, it could be impairment of contracts, it could be a bill of attainder, or it could be an ex post facto law, right? Those are certain things you'll look out for. Ex post facto law is retroactive punishment. A bill of attainder is a law or statute that specifies someone for punishment without a trial. And then impairment of contracts is a law that interferes with existing public or private contracts. Maybe like a curfew violation, you could argue is impairing contracts of the nightclubs and things like that. So, I mean, constitutionally, you just want to take that, your toolbox out and just argue. They could argue that this violates due process. This violates equal protection. This violates the Sunshine Law. This law wasn't enacted properly. It's important to note that general law, special law versus general law of local application, or the, what's necessary to enact a law in Florida and things like that. I'm sure there's some things additionally that we could talk about when it comes to con law, but just try to remember like the main points that they're usually vague, overbroad, usually implicates due process, usually implicates equal protection. Natalia, if you have a question, just put in the chat and I'll address it. It usually addresses due process, equal protection, vagueness, overbreadth. Those definitely come up a lot. And then, Florida specific issues like Sunshine Law and homestead exemption, enacting a law in Florida, uh, general law versus special law versus general law of local application. Access to courts definitely comes up a lot. Just try to argue as many things. It's very similar to torts, where it's like you're almost throwing the kitchen sink at them. Like, these are all the different claims of action. Be like, these are all the different reasons why this act or ordinance could be determined to be unconstitutional. All right, so some questions. We can just say how the court will likely rule, not what we think this party will prevail, right? Yeah, I agree with that. Weak conclusions. The court will likely find instead of therefore A will prevail. Because what if you're wrong? You leave a bad taste in the reader's mouth if you are adamant about an incorrect conclusion. Whereas if you say, hey, this is what they'll probably find, it sounds a little bit better. A good statement for state action means that it has to be governmental, right? It can't be a private party. And just because a private party receives government funding doesn't automatically make it state action. It's only state action if it's, something that the government is doing. Remember that Florida has waived sovereign immunity in tort claims for planning decisions, but not operational decisions. So you kind of want to have that discussion. An individual cannot sue the state of Florida, but they could sue a state actor in their individual capacity for declaratory relief. So do we use strict scrutiny to analyze or Kluger for access to courts? Definitely strict scrutiny, right? Access to courts is a strict scrutiny argument, so it has to be necessary to achieve a compelling government interest if they're going to impair that right to access courts. But the counter argument is under the Kluger doctrine, B could argue that it would be allowable because there's an overarching public necessity. It's not likely that the Kluger doctrine is going to win. That's like a very rare case. It's literally the Kluger case, but Kluger v. White case. But you want to have that argument. Remember that counties are the ones, local governments are the ones that impose taxes, property taxes, ad valorem taxes, not the state. So the state can't collect property tax. That would be impeding on the local government's ability to collect taxes. They may test you on municipal bonds, GO bonds, GO bonds, general obligation bonds versus revenue bonds. GO bonds, general obligation bonds, are paid for by taxes and subject to a referendum, and revenue bonds are paid for by the revenue of the actual project and are subject to feasibility studies. So a GO bond, a general obligation bond, would be like a public school or a park, right? It's paid for by taxes and the people need to vote on it. Whereas a revenue bond would be like a toll bridge or an airport where, the tolls and the airlines will pay revenue that will support that type of bond issue. Um, let's see. Yeah, governmental action in nature. I like that for state action. And then what about congressional and federal powers? Good to know, or doesn't come up a lot. I mean, I've seen an essay where they've talked about, commandeering and the uh, commerce clause and the dormant commerce clause and the privileges and immunities. I mean, they could test that. So like, you do need to know federal con law. You do need to know con crim law, but mostly it's going to be the state of Florida or, Orange County or Dauphin County in Florida. And then you'll have that kind of a analysis and argument. And then with con crim, they could also do criminal law, like literally, where it could be murder, manslaughter, and things like that. I've given people, access to what I think are the best resources to study down the stretch. Um, I said my essay guidebook, like everything I'm talking about, I'm sure I go into uh, deeper analysis in my book. So, definitely go through my book. And if there's anything I missed today, you can read it in my book. Also, like I said, the Florida multiple choice Q bank, especially the FBBE quizzes, I would try and do in their entirety. Another thing that's actually a good website. His name is Hornsby, so hornsby.com/crimes. And he goes over all the Florida crimes and their specificities. I mean, it's not super heavily tested, so I don't talk about it too much. I talk about it in my book for sure, but like you can go to homicide and talk about first degree, second degree, third degree murder, manslaughter, and the, different sentencing guidelines. I mean, if you get a criminal law essay, it should be pretty manageable, right? And typically they'll give you like, this is how they define, you know, aggravated assault in Florida. This is what happened. Could they prevail under the statute? And then it's kind of just like almost like an MPT essay where you're just applying the statute and making the arguments and going both ways with it. So, con law can be really tough because it's um, con law can be really tough because it's different lenses, right? Florida lens, federal lens, con crim lens or crim pro lens. So, really sticking to your guns and reciting the key points like heightened right to privacy that's explicit. They do have the right to a jury trial. You have a fundamental right to work and to be in a union and to vote and to travel and things like that. And then doing the different scrutiny levels and making sure you can talk about sunshine law and homestead exemption and enacting the law in Florida and different things like that. Um, okay. Someone already asked a real property question in the chat. You guys have no patience. But adverse possession, 7 years, and Florida prescriptive easements, 20 years in Florida. Yeah, that's correct. So Florida, things that come up often, right? Adverse possession and easements. If there's an easement, I recommend umbrella statements. Don't just say this is a prescriptive easement because it was XYZ. Say there are many types of easements. There's affirmative, there's negative easements, there's prescriptive easements, there's easements by necessity, there's easement of pertinent, easement and gross, right? Like different types of easements, and then say this easement is likely easement by prescription. The statutory period is 20 years. It's open, continuous, adverse, notorious, and hostile, and, go into the discussion, but give them the umbrella statement about the different types of easements. There's an easement by prior use and easement by necessity. Florida even has a statutory easement by necessity if it's like agricultural land that's so hemmed in that there's no access to a public road. But there's also, just regular easement by necessity where, right, they have no access to a public road. It doesn't need to be a farm or something. It could just be any house or any place. So adverse possession, right, it's open, continuous, exclusive, adverse, notorious, and hostile for the statutory period of 7 years. You can take adverse possession with or without color of title in Florida. With color of title means you have some deed or some document purporting title. Without color of title means you're just squatting on the land. If it's without color of title, then you have to have actually paid the taxes on the property to prevail for an adverse possession claim. Real property could be about mortgages, right? A mortgage is a loan secured by property, and it could be uh, it's a loan secured by property, and there could be a foreclosure action in the case of a default. A foreclosure action is the forced sale of the property, and there could be an equitable right of redemption before the foreclosure sale where the mortgagor can recover the property by paying the money, or if the county provides for it, there could be a statutory right of redemption where they're able to pay off the mortgage price even after the sale for a certain period of time if the county provides for it. So mortgages, loans secured by property, there could be a foreclosure sale. In the event that the foreclosure sale does not pay off the senior mortgagee, they would need to seek a deficiency judgment, which is how to collect personally from the property. There could be a subject to or expressly assumed mortgage. Expressly assumed means that the new party is primarily liable. Subject to means the new party is secondarily liable. Junior mortgagees are necessary parties at foreclosure sales. So make sure you really understand, foreclosures and mortgages, deficiency judgments, and that whole conversation. There's valid and enforceable terms in mortgages, like a due on sale clause or a no early prepayment clause or an acceleration clause, right? In the event of a failure to pay and things like that. There's an equitable mortgage if it's like a mortgage that wasn't recorded properly, but still operates as a mortgage. Going back to easements, so overuse of an easement will not lead to termination of the easement. It'll lead to injunctive relief, like you have to stop overusing it, and potentially what's known as a surcharge. A surcharge is payment for that easement. Natalia, you can answer Maria's question because we talked about that yesterday. And then, mortgages, easements, adverse possession, those things could definitely come up. Deed formalities and just like the deed itself. Deeds need to be signed by two subscribing witnesses. They need to accurately describe the land, the grantor, and the grantee. Obviously, a land sale contract needs to be in writing to conform with the statute of frauds. There could be a whole essay about concealment or failure to disclose, right? There's a duty to disclose under Johnson v. Davis. Known defects or defects that they should have known about. So that's definitely a concealment argument or misrepresentation or a failure to disclose. And you want to have that whole conversation. Definitely know the different types of deeds: a general warranty deed, a special warranty deed, and a quitclaim deed. A general warranty deed has the covenants of the right of seisin, the right against encumbrances, and the right to convey, as well as the future warranties of quiet enjoyment, further assurances, and general warranties. There's the merger doctrine where the contract will merge into the deed. There's also merger when it comes to an easement, right? If there's adjoining properties that have an easement and then A buys B's property and A merges the properties together, that could extinguish the easement. But definitely look into deed formalities and different types of deeds and have that discussion. Very important in Florida. Florida is a pure nose jurisdiction, and Florida is a lien theory state. So, there's a bunch of people out there who come from New York and California and want to take the Florida bar. They've been practicing law for 30 years and think they're just going to pass the Florida bar exam based on their knowledge. So what Florida tries to do is test Florida specifics. Like I said, modified comparative fault for torts. We talked about the sunshine law and the homestead exemption. And then for real property, we would talk about lien theory and pure notice. Pure notice jurisdiction means that subsequent bona fide purchasers will prevail. The last bona fide purchaser. The last person to take for value in good faith without notice. And then notice can be actual or constructive. Actual notice means they had notice, and they affirmative notice, and constructive notice could be inquiry notice or record notice. Inquiry means a reasonable inspection of the property would have put them on notice. And then uh, record notice means that it's in the county records and it's been recorded. You could maybe talk about like a wild deed. If it was outside the chain of title, then maybe they wouldn't have had notice or something like that. An action to quiet title is like if there's a conflict to title, we'll bring the opposing parties in and determine who has proper title to the property. So that's a pure notice jurisdiction that Florida is. Florida is also a lien theory state instead of a title theory. Lien theory means that an encumbrance on the property will not sever a joint tenancy with right of survivorship. So if A and B are JTROS, A takes out a loan on the property and then A dies, the lender cannot foreclose on the property. The lender will need to go after A's estate personally because the loan on the property operated as a lien and didn't give them title. So lien theory, pure notice jurisdiction, very important. Equitable conversion comes up in Florida where unless it's agreed upon otherwise, the buyer becomes the equitable owner after the contract is agreed upon before the deed is recorded. So during that period of escrow, the buyer incurs the risk of loss, and the buyer, they're equitably owns the property. So if the buyer were to die, their estate would have to go through with the sale of the property, with the purchase of the property, and vice versa. If the seller died, his estate would have to go through with the sale because the property has already been equitably converted. So, some big buzzwords for real property are like equitable conversion, lien theory state, pure notice jurisdiction, identifying the different types of easements, identifying adverse possession, deed formalities, the different types of deeds. Also, they could talk about a equitable servitude or real covenant. These are promises tied to the land. Real covenants are remedied by monetary relief. Equitable servitudes are remedied by injunctive relief. And then they could have a whole essay for real property. Just like I said, it could be about concealment, land sale, and duty to disclose and all that. It could also be a landlord-tenant essay where the landlord has the duties of habitability and quiet enjoyment. The tenant has the duty to pay rent and not commit waste. And waste could be actual or affirmative. Waste could be permissive, or waste could be ameliorative, where it actually improves the property, but they're still liable because they didn't have the permission. You know, tenants and life estate holders have that duty not to commit waste. Yeah, it could be about a life estate and a remainder man and a fee simple. They don't tend to go into that too much, but you should know that like a remainder man takes after life estate. A remainder man cannot partition the property until they've received their interest, right? So they would have to wait it out in that type of scenario. Yeah, partition is if you're going to divide the property physically, or more commonly of a judicial sale of the property, and then they'll split the proceeds if there's a partition. Definitely knowing about joint tenancies with right of survivorship, tenancies in common, and tenancies by the entirety. A joint tenancy with right of survivorship has the four unities of time, title, interest, and possession. So those are the four unities of a JTROS, where a tenancy by entirety is a JTRS plus the element of marriage. And Florida has eliminated the need for a straw man. So you can just marry your wife and create a tenancy by entirety without the need to convey the property to a straw man and then reconvey it back to you and your wife as tenants by the entirety. With the landlord tenant essay, a good mnemonic is your period will suffer for tenancy for years, periodic tenancy, tenancy at will, and a tenancy at sufferance. So like a holdover tenant, and notice requirements for how long they have to give the particular party to evict them, right? And I have all that information in my book. It's different in federal and Florida, so I don't want to confuse y'all. And it's different for residential and commercial real property. But those are the things that I would focus on down the stretch, or like the dates and times and the numbers that you're exactly going to use on test day, because now's the time to commit them to rote memory. So I think in general, real property is a tough subject. There's a lot of different things that can be tested on it, but just stick to your guns and just write about the things that you've seen commonly. And the more the merrier. If there's a deed, talk about deed formalities and the different types of deeds and the fact that it has to be in writing to conform with the statute of frauds and all those different things. Um, if there's some encumbrance on the property, talk about potentially the implied warranty of marketable title so that, there's implying that there's no encumbrances on the property, there's no strange zoning ordinances, there's no threats of litigation, there's no liens or easements, or it wasn't acquired via adverse possession. These are all things that can make title unmarketable. In general, like I said, real property is a really tough subject, but read over my book and hopefully get these main points. But don't forget that Florida is a lien theory state and that Florida is a pure notice jurisdiction. And if you're discussing something like pure notice, talk about what a bona fide purchaser is, talk about what the different types of notice are, and then you can arrive at the necessary conclusion. Um, so let's see. Yeah, like Natalia said, it's statutory right of redemption is by county in Florida. So you don't want to just say blanketly that Florida doesn't allow for statutory right of redemption. Some counties do, some counties don't. Would be proper to say an easement is a non-possessory interest in land use for a specific purpose? Yeah, I like that. A non right distinguish between easement and a license. A license is revocable, whereas an easement will typically run with the land. It's tied to the land. Easement and gross versus easement appurtenant. Easement appurtenant is land to land, where easement and gross is personal in nature. It's held by like a utility company or something like that. When we were talking about takings, remember there could be a regulatory taking or a possessory taking. Possessory taking is the government physically takes the land, where regulatory taking is where the government enacts a law or regulation that essentially renders the property economically unviable or deprives them of their investment-backed expectations. Um, so um, for a homestead, they have the wife has the option to either take a life estate and a remainder in the with the child. That's the default rule, or they could share a fee simple with the child in a homestead scenario where someone dies and leaves a homestead to a wife and they have children. Um, Permissive waste is when you let the property rot. You see there's a little drip in the ceiling and you just don't repair it by any means, and then it turns into a huge flooding scenario. You permitted the property to go to waste. Um, and then um, I'm not sure what that question is, Maria. But anyway, I'm going to continue to go to family law. So again, contracts, torts, con law, real property. That's the big four, right? They're going to be tested, at least two of the four of them, if not three of the four of them. So make sure you know them well. Family law, I think, is pretty simple, right? You're talking about jurisdiction, the UCCJEA, which Florida has adopted, and the 6 month rule, where the either party has lived for the past 6 months or the child has lived for the past 6 months will give them jurisdiction, a minimum contacts analysis and a venue analysis. You want to have that beginning analysis for uh, for family law. And then you're talking about the parenting plan, equal distribution, alimony, child support, and modification of the divorce. Remember that the concept of the exclusive continuing jurisdiction, where the party or the court that originally um, uh, ruled on the final settlement agreement, the final marital settlement agreement, will have continuing exclusive jurisdiction for modifications of that agreement, unless there's reason for another court to take over. But typically, it'll be the court that originally ruled on it. For the parenting plan, there's different types of shared or split or sole or dynamic or parallel or ultimate. There's a lot of terms that they could use for time sharing, but pretty much sole is disfavored because you do have a constitutional right to be involved in the upbringing of your child. So sole parental uh, time sharing is only in the case where one parent is totally unfit to be involved in their child's life, maybe major drug problems or uh, abuse of the child or something like that. Split or shared is typically, 50-50 is the preference. And you could do that. Then there's what's known as parallel, or I've heard it called ultimate or even dynamic, which means that, mom will be in charge of gymnastics, dad will be in charge of football, or whatever it may be, like based on particular topics that um, they're more equipped for. So different types of time sharing agreements. And remember, there is a presumption that the parent should have a right to be involved in the upbringing of their child. So it's difficult to award sole parental responsibility. Um, Equitable distribution means that marital property will be divided equitably. So property that was um, uh, received during the marriage, if it was received by gift or by devise to an individual, it won't be considered marital property. But otherwise, everything gained during the marriage is marital property. Even, the father's pension or the mother's, salary, things like that, because you're a marital unit. Things before the marriage are non-marital property, but marital property will be divided equitably. Um, and then there's remember, alimony can be waived in a prenuptial agreement, but child support cannot be waived in a prenuptial agreement. So alimony, there's different types of alimony. Florida's abolished permanent alimony, but we allow for bridge the gap, pendente light. We allow for durational and rehabilitative alimony. So all these temporary forms of alimony are possible. You definitely want to list them all and discuss them. And then, for child support, the best interest of the child, different factors like, the child's preferences, if they're old enough, the continuity of the child's education and, location and all these different things that you could consider for child support or alimony. Alimony, you typically think of the statutory guidelines where you look to see how much one of the parents made compared to the other and what's necessary for them to continue on their lifestyle as it has been established. A divorce is proper in Florida if the marriage has been irretrievably broken or one of the parties has been adjudicated incompetent for 3 years. A divorce versus an annulment is if the contract, as if the um, marriage never existed. A divorce is termination of the marriage. Adoption rights. So biological children will have the same rights as adopted children will have the same rights as biological children. And in Florida, there's a right for grandparents to have visitation rights for their biological grandchildren. Uh, the only way that a adopted child um, uh, could still take from their parents' estate is if it's a step parent adoption. Like typically, an adoption will sever inheritance rights for an adopted child, but if it's a step parent that adopts a kid after the kid's natural father or mother passed away, then we will allow for uh, inheritance because it was a step-parent adoption and not like a formal adoption that would sever parental rights. Yeah, I think that's a good mnemonic. Jurisdiction, venue, parenting plan, equal distribution, alimony, child support, uh, divorce, and distribution. Remember, there'll be a modification of the final settlement agreement if there has been a substantial change in circumstances. It no longer needs to be a unanticipated change. It just needs to be a substantial change. If you get the family law essay, just think about your cousin who got a divorce and what they went through and the different considerations. Um, so then there's ethics. So ethics, I of class, there's really great ethics statement that I think you should all have memorized, which is where the rules of ethics come from and what the punishments are for failing to follow these ethical rules. I'll just read it off the paper for y'all one time because I think it's nice. And if it were me and I was sitting there while they're starting the Florida bar exam, I would just be reciting this in my mind, which is the ethical duties of Florida lawyers are outlined in the decisions of Florida Supreme Court, the Florida rules of professional responsibility, the ideals and goals of professionalism, the oath of admission to the Florida bar, the creed of the Florida bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. I would start every ethics discussion off with that. It's just a nice introduction, a nice umbrella statement. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida rules of professional responsibility, the ideals and goals of professionalism, the oath of admission of the Florida bar, the creed of the Florida bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. So, there's conflict of interest usually comes up the most where there's the idea of imputation and screening and former clients and prospective clients, and they need the informed consent and they need to believe that they can represent the client without sacrificing their professional judgment. In general, you should seek the informed written consent from a client if there is a potential ethical conflict, right? Other ethical duties are like the duty of confidentiality, the duty of competency, the duty of candor, the duty of decorum. They talk about attorney's fees a lot, like if it's a contingency fee versus a referral fee. Contingency fees, they do need to have a signed writing explaining how the fee will be calculated, and then at the end, explaining how the fee actually was calculated. And contingency fees are not allowable in domestic cases like divorce or criminal cases. And then referral fees are disfavored in Florida, but they will be allowable so long as the referring party participates in the representation in some manner. They also will test like advertising and solicitation. So, the rules for when you have to send advertising materials, it has to include the name and the field, and they must be registered with the Florida Bar. It can't be misleading and contain false statements. And then solicitations, you can solicit someone who's an existing client or that you have a close personal or family relationship, but not anyone else. And then for the accident victims in Florida, you have to wait 30 days before you send them a solicitation as a personal injury attorney. So, ethical issues, I think you should really be good on and you should do really well on it. But, it's something that I would address right away because you're going to write about ethics, you can have it memorized. And if you do a good job discussing it, you'll get your points. Whereas if you save it for the end, you could run out of time and then not have the opportunity to get the points. So one thing I'll do before I talk a little bit about Florida multiple choice, and again, Florida multiple choice is hard to do a complete review on. I'll just talk about some of the main points, but I want to go over my essay guidebook, see if there's anything that we kind of missed or whatever. Right, UCC versus common law, predominant purpose test, special rules that apply to merchants, like the ballot forms provision, the knockout rule, the confirmatory memo rule, the firm offer rule, the lack of need for consideration for modification, and the 30-day rule for responding to a request for further assurances. That's if there's been anticipatory repudiation, they could send a request for further assurances. I said that you should talk about what type of contract is it, unilateral contracts, bilateral contracts, installment contracts will have the opportunity to cure, requirement contracts, output contracts, options contracts, which need consideration to at common law, but under the firm offer rule, no consideration is needed. Divisible contracts, quasi contracts, right? Formation, offer, acceptance, consideration, mirror image test, ballot forms provision, knockout rule, UCC essential terms test, mailbox rule, invitation to deal, and an advertisement that's not binding unless it's very specific with terms of how to accept, defenses, statute of frauds, and then the exceptions, right? So the my legs mnemonic and the swap mnemonic. We see there's like 2 Gs for healthcare guarantees, even newspaper subscriptions, I think need to be in writing. Mistake, unilateral mutual mistake, defense to formation, consideration, fraud, duress, misrepresentation, undue influence, incapacity, including intoxication, infancy, immaturity, incompetence, illusory contracts, empty promises, illegality, procedural and substantive unconscionability, impracticality, impossibility, frustration of purpose, I mean, I've seen these tested in California, never in Florida. Unclean hands, latches, and acquiescence. Breaches, definitely discuss if it's material or immaterial. Anticipatory repudiation, perfect tender rule under the UCC. Modifications require consideration under common law, but merchants under the UCC, just good faith. Legal relief like expectation, consequential, incidental, lost profits, lost wages, reliance, restitution. Equitable relief like court ordered specific performance, injunctive relief, reformation, rescission, replevin, promissory estoppel, enforcement of quasi contract. Replevin is if it's like collateral that you need to take back or it's stolen goods, you would need a writ of replevin. Parole evidence, good issue, right? Non-compete agreements, liquidated damages clauses, accord and satisfactions, third-party beneficiaries. I don't think I mentioned. A TPB can be intended, named or ascertainable in the contract, or incidental. An intended third-party beneficiary has rights and can stand in the shoes of the original party to enforce the contract. The rights vest when they either detrimentally rely on a contract or sue on a contract. So everything I talked about in contracts, pretty solid. I haven't read this book in a while. I was writing it a couple years ago over winter break. All right, so Florida's modified comparative fault. They've abolished joint and several liability and punitive damages 3 times compensatory, $500,000. Talked about all that. Talk about them on every essay. Negligence, duty, right? The Good Samaritan rule protects rescuers from liability as a result of rescue efforts. A person who negligently puts themselves in a situation that invites danger, right? They invited the danger, can be held liable for the injuries to a foreseeable rescuer, but not a firefighter because it's within the um it's when their job duties, unless it's like outside of their job. But my brother's a firefighter. He can't sue someone for getting injured while rescuing them from a fire. Negligence per se, we talked about, responding superior, res ipsa loquitur, strict liability, and abolishing the one bite rule. Breach, right? So causation, actual, proximate, superseding, and intervening. Cause compensatory for pain and suffering, emotional distress and mental anguish, medical expenses, loss of wages, diminished earning capacity, loss of consortium, out-of-pocket expenses, right, for economic loss doctrine. So you can't recover for purely economic losses because that would more be a breach of contract claim. Eggshell plaintiff rule, NIED, negligent infliction of emotional distress. Sometimes there are exceptions to the impact rule, like mishandling of a corpse, inaccurate disclosure of HIV test, claims involving wrongful birth, such as stillborns, defamation, invasion of privacy claims. The impact rule has been modified, right? So you don't always need a physical impact. You can get emotional distress when it be permitted, or one suffers death or significant discernible physical injury when caused by psychological trauma resulting from a negligent injury imposed on a close family member within the sensory perception of the physically injured person. So, that's a NIED bystander case. Florida dram shot means that you could be liable, but you're not liable for injury or damage caused by resulting from the intoxication of a person. I mean, unless you totally overserve them and it's super clear that you shouldn't, right? But typically they'll be protected. They never really test about dram shop laws. I seen one essay where they said, do not consider dram shop laws. So it's something that they'll tell you not to write about. Intentional torts, assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, IID, malicious prosecution, intentional endangerment, reckless driving. Defenses to intentional torts include consent, self-defense, and defense of others. Necessity, like for trespass, docking your boat. Statute of limitations, which have been reduced to 2 years now. Res judicata and collateral estoppel, claim preclusion, issue preclusion. So defamation, I said, talked about a lot. Invasion of privacy, I didn't mention, but the mnemonic that you memorize is I flap, intrusion upon seclusion, false light, appropriation, misappropriation, and public disclosure of private facts. But Florida does not recognize a separate tort for false light. So you can get a little point for there. Here's some good stuff on premise liability, like we talked about. Products liability, which we talked about. Wrongful life is not recognized in Florida, only a wrongful birth claim, wrongful death, survivorship claims, medical malpractice. I mean, I kind of wrote this, I did my best. I wrote this before AI, and I really didn't like try to write it looking at notes. I try to write it just like I'm talking to y'all now. So like medical malpractice, I didn't get too deep into it. I just said there's caps on non-economic damages. They have the right to choose mediation or arbitration. I didn't even include the time periods because they rarely test it. If they do test it, you just want to be able to write about it. You don't want to like necessarily spend too much time memorizing things that aren't highly likely to be tested. So nuisance, public or private nuisance, we talked about. For con law, you know, um, state action, standing, justiciability, Fifth Amendment, due process, equal protection, freedom of speech. This is a good one to read about. Traditional public forum versus designated public forum versus limited public forum versus non-public forums, and different types of unprotected speech. Uh, Freedom of religion, fundamental rights, right? Fundamental rights. They also include right to travel, right to vote, right to work, join a union, right to privacy, right to be a candidate, right to be free from governmental takings, access to courts, due process rights, right to bear arms, right against reasonable search and seizures, the right to counsel, right against self-incrimination, right against double jeopardy, right to speedy trial, right to confront witnesses, right to trial by jury in certain circumstances, right? Access to courts I talked about with the Kluger Doctrine. The different scrutiny levels are important. Vagueness and overbreadth come up a lot. Separation of powers, I think, is the issue that most people miss on their essays that you want to talk about. Takings and eminent domain, 10th Amendment state sovereignty, 11th Amendment state sovereignty. So Florida's waived sovereign immunity for tort claims involving operational decisions, but not planning decisions. And then these things could be coming up if it's a federal essay. Commerce Clause, Dormant Commerce Clause, privilege immunities, anti-commandeering, ex post facto, contract clause, bill of attainder, double jeopardy, right? Things that could come up. And then I said in order of likelihood to appear in a Florida essay, sunshine law, homestead exemption, enacting law in Florida, types of law in Florida, home rule power, types of counties, special legislative sessions, separation of powers again. Constitutional officers include the lieutenant governor, the CFO, the commissioner of agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers, supervisors of elections, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. They have vested duties and must complete relevant ethics courses. Amendments to the Constitution require 60% approval from voters to pass. Defamation, right? It's not protected by the First Amendment, express right to privacy in Florida, the right to work. I talked about go bonds versus rev bonds. Excessive bail, you could talk about under the Eighth Amendment. Bail is excessive when set at a figure higher than an amount reasonably calculated to ensure the assured government interest. Taxation considerations. So remember, ad valorem taxes are collected by the counties and municipalities, not the state. Rights of convicted felons. So this would be like clemency and restoration. If you haven't had your voting rights restored, then you don't have the right to vote. So convicted felons don't have the right to vote in Florida. No pocket veto in Florida. Florida can render advisory opinions. Like we said, judicial procedure where they'll present a bill to the governor to either veto or sign. And there's no pocket veto in Florida. This is a good one right here. Prohibited subject matters. Special laws, as well as laws of general laws of application, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petite juries, conditions present to bring civil or criminal claims, venue rules, and rules of evidence. These subject matters are preempted by state law. Original jurisdiction of the Supreme Court, right? Like bond validation proceedings, imposition of death penalty, and things like that. And then, for the con crim law essay, like we talked about, search and seizure, Miranda rights, custody interrogation, Sixth Amendment right to counsel and speedy trial, exclusionary rule, fruit of the poisonous tree doctrine, warrant requirements, right, issued by a neutral magistrate, and accurately identify the items to be seized or the people to be arrested. The spaces mnemonics, search and to arrest, plain view doctrine, all exception, consent as in circumstances, stop and frisk doctrine, Terry stop, reasonable expectation of privacy, right? Stand your ground laws. So Florida has stand your ground laws. You're justified in using or threatening to use force. Accept deadly force unless it's reasonably necessary. Impermissibly suggestive lineups. So that comes up a lot, not a lot, but it could come up where it's like, if
we're trying to arrest Kevin Hart and we put Shaquille O'Neal and LeBron James and some other basketball player, it's like, okay, that's not fair. This guy's impermissibly suggestive by showing a major height discrepancy. So that would be an example of an impermissibly suggestive lineup. Again, I put this guy Hornsby's crimes in my book because I think it's super solid that you could go through robbery and murder and defenses to murder and manslaughter, theft, crimes, arson, attempts, solicitation, vehicular homicide, a lot of good stuff there. For real property, I include this vocab list. Just in general, the more vocabulary terms you know, the better. But like, this isn't super necessary for Florida. It's just like it can help you if you uh, don't know some of these vocabulary words and you want to learn them more, right? Fixtures are things that are, affixed to the property and they'll stay with the property. Unless it's a trade fixture, you could remove it as long as you don't um, uh, damage the property or you pay for the cost of restoration. So remember I said Florida's a lien theory state, pure no jurisdiction, BFPs, actual inquiry or record notice, different types of tenancies, JTROS, tenancy by entirety, tenancy in common. Remember, partition would be like a physical partition or judicial sale to split the proceeds. Mortgages, foreclosure sales, deficiency judgment. I don't think I mentioned this. A purchase money mortgage, they have the highest priority when the money borrowed is used to buy the property. I talked about expressly assumed, subject to, equitable right redemption, statutory right redemption, due on sale clause, acceleration clause, no early repayment clause, equitable mortgage, a deed in lieu of foreclosure means instead of selling the property, you're just going to sign the deed over, and that's allowable so long as it's fair and equitable in the circumstances. Different types of easements, right? Remember, prescriptive easement is for 20 years. There's no negative easements for light or air under the Fontainebleau versus Eden Rock, but you do have riparian rights or water rights, reasonable flow or prior use theory. Difference between a license and an easement. A license is revocable. A surcharge for the overuse of an easement or declaratory relief. Real covenants by legal relief. Equitable servitudes for injunctive relief. Adverse possession, you can think of tacking where, someone could tack on to meet the 7-year requirement. Color of title is with a defective deed purporting title. Without color of title, you have to pay the property taxes. Homestead property we talked about. Um, you know, it's protected, half an acre inside a municipality, 160 contiguous acres outside municipality. Habitability and quiet enjoyment are landlord duties. A constructive eviction is when the landlord has violated their duty of habitability and the person actually moves out and then files for constructive eviction. The duty has to pay rent, avoid waste. We talked about tenancy for years, periodic tenancy, and these are the notice requirements. 60 days notice for residential periodic tenancy, 90 days notice for non-residential periodic tenancies for year to year. Quarter to quarter is 30 days for residential, 45 for non-residential. Month to month is 15 for both, and week to week is 7 days for both for eviction notices. Tenancy at will, they can either party can terminate at any time. And then the holdover tenant, Florida, you just have a right, you just have a duty. And Florida, you have a duty to deliver legal and actual title. So you have to deliver the legal title, and the landlord will be responsible for a holdover tenant if they rent out a property and there's a holdover tenant there. Um, you cannot use self-help to regain the possession of the premises. You would have to go get the sheriff to carry out an eviction. So land sale contracts, statute of frauds, duty to disclose, as is clauses are generally not going to be um, uh, they're not going to absolve a residential real property seller unless it's specific disclaimer, like the roof or something like that would allow for absolving them. Concealment, misrepresentation, puffery is just saying like, oh, this is the best house ever, but it's not really a misrepresentation. Um, Marketable title, like we said, equitable conversion, the risk of loss shifts to the buyer, deed formalities, um, two witnesses, special warranty deed versus the general warranty deed. Special warranty deed is just for the time you had ownership. You're guaranteeing no title defects, but general warranty deed is all the way through the title with size and right against encumbrances, right to convey, quiet enjoyment, general warranties, and further assurances. Some really good stuff with property. Family law, I think, yeah, mentioned the UCCJEA. Circuit court is the proper court for, divorce, parenting plan, best interest of the child, split parenting, ultimate parenting, or sole parenting. Remember, I also called ultimate, dynamic, or parallel. Equitable distribution, you split up marital and non-marital property. Alimony, they've no longer doing permanent alimony. A short-term marriage is under 10 years, a long-term marriage is over 20 years, and that'll all be considered. You could be grandfathered into permanent alimony. Child support, right? Any deviation by more than 5% will require the judge to show findings to support the deviation. Um, if a child is spending 20% of the nights with the person paying support, there must be an adjustment. You could get attorney's fees in a family law dispute if they agree upon it. Like I said, irretrievably broken. Florida's a no-fault divorce state, or mentally incompetent for 3 years or more. A modification means a substantial material change in circumstances, no longer requires it to be unanticipated. Prenups, obviously, they have to be in writing in consideration of marriage. Adoptions, they have the same legal rights. All adoptive parents must be approved through an adoption home study, as well as meet any additional requirements from the private agency. Grandparents, aunts, uncles, and siblings can adopt through kinship adoption, which is quicker and less expensive compared to regular adoptions. And then ethics, duty of confidentiality is broader than the attorney-client privilege, so it survives the representation. And it's from any source. Attorney-client privilege is just what the client said to the attorney. Duty of confidentiality could be, my brother's being represented by an attorney, and then I email the attorney information about the case. Well, that's from any source, so it's even broader than the attorney-client privilege. It's an ethical duty. Duty of competence, right? They have to have the knowledge, skill, thoroughness, and preparation, but they can become competent via study or association with a learned mentor. Duty of candor, meaning that not making any false statements to the court. Decorum, upholding the standards of honor, integrity, and fair play. Conflict of interest with respect to former clients. They cannot represent a new client in a case which an old client will be adversely affected. And with respect to prospective clients, they cannot represent a client that will, compromise their professional judgment. You could always get a signed written letter, that the client will allow for this if you have consent. Imputation means that a conflict can be imputed to the rest of the firm unless they're timely screened out and the prospective client gets notice of the conflict. Attorney's fees need to be reasonable, not unconscionable or overreaching. Not to commingle funds, right? Separate account for your operating expenses and fees collected for advanced cost. Contingency fees, they need to be in writing, and they have to have a description of how they will be paid and a final calculation, and not allowable in criminal cases and domestic cases. Referral fees are not ethical unless they actually participate in the litigation or in the representation. Interest in client property. The client must get informed consent. The agreement must be fair and reasonable. And the client must also be advised of the opportunity to seek outside counsel. Advertisements, right? They have to include their name and field and the registration with the bar. It can't be misleading. Solicitation, like we said. You can't solicit someone who's not a close personal or family relationship, and you can't send a letter to an accident victim unless 30 days have passed. And if you sell a private practice, you have to sell the entire practice. You can't just sell like one area of it, and then you can't sell your practice and then compete with it afterwards. So this is rules of private practice, right? You have to be barred unless you could be, um, in-house counsel or pro hac vice, like just doing a singular dispute. And then mediation is ADR, alternative dispute resolution. Mediation just leads to a suggestion where arbitration is binding, and it leads to a decision that there's going to bind them by. And then one last time for good measure, because I want you guys to all write this on your essays, maybe twice if you have two ethics essays. The ethical duties of Florida lawyers are outlined in the decisions of Florida Supreme Court, the Florida Rules of Professional Responsibility, the Ideals and Goals of Professionalism, the Oath of Admission to the Florida Bar, the Creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. So my grandma, rest in peace, always said, be a good person, doesn't matter if you pass or fail, just be a good person and everything should work out well for you in life. As far as the Florida multiple choice section, again, I really highly recommend you do the FBBE quizzes over and over until you're getting 100%. Try to memorize the dates and times that are associated with civil procedure, criminal procedure, and evidence. For business entities, they're going to test corporations and partnerships way more than secure transactions um, and commercial paper. And then for wills and trusts, they're going to test wills more than they're going to test trusts. So, for trust, think about spendthrift provisions, and who can pierce that would be alimony, child support, or taxes. Think of the duties of the trustee, right? The not to commingle, and the duty of loyalty, and to prudently invest, and to separate and earmark funds. And just because there's been a diminution in trust assets doesn't mean that the trustee is automatically breached the duty. It could just be the stock market went down. A trust will not fail for want of a trustee, meaning that the court can appoint a trustee. A settler needs to have, sound mind, intent, trust race, ascertainable beneficiaries, proper purpose, right? Um, trust, there's different types of trust, like discretionary trust, mandatory trust. You can have an oral trust. You could have a totem trust, which is a payable on death account. You could have a testamentary versus an inter vivos trust. Obviously, testamentary trust has to be in writing because it's complying with will formalities. And then trusts are assumed revocable in Florida unless they're made irrevocable. I feel like you guys can do good on trust essays. They're definitely manageable. The Cypress doctrine attests a lot, where if a trust, is supposed to go to a charity, but that charity no longer exists, they can just pick another charity to satisfy the purpose of the settler. The hallmark of trust revocation and modification is settler intent. For wills, remember that a um, Florida is a per stirpes distribution state, which means if A dies and has kids B, C, and D, and D's dead as well, and D has kids E and F, it'll be split 33% A, B, and then D's kids E and F will each get 16.5%, right? Like it'll split on the first stirpial level. Um, with wills, it has to be will formalities, so attested by two witnesses in the presence of each other. Obviously sound mind and intent for a will. Florida does not allow for holographic wills, like handwritten wills that don't comply with will formalities. And Florida does not allow for partial revocation. So you totally need to destroy a will for it to be revoked. A codicil needs to also comply with will formalities. A codicil is like a will amendment. So if you destroy the codicil, the will still stands. If you destroy the will, the codicil will be revoked as well. Think of the codicil as like the apple of the tree. And if you pick the apple, the tree still stands. But if you cut down the tree, then the apple will no longer stand. Um, remember half-blood distribution and tested distribution, where if there's a kid from a previous marriage, then the surviving spouse will get half, and then the kids will split the other half. If there's no kid from a previous marriage, then just the surviving spouse will get the total amount. I think Will's questions can be tough. There's also, remember, Florida has a anti-lapse statute, which means that if A divides property to B, but B is dead, and any of B's family could step in the shoes of B and take, and we won't say that the gift has lapsed. Ademption versus abatement. Ademption means that the gift no longer exists, and abatement means there's been a diminution in value, so it'll be proportionally reduced. If it's like an account for $1 million and now it's $800,000, there's two kids, they'll get $400,000 a piece instead of $500,000 a piece. So, wills is manageable. I think it's fact pattern specific, so you got to read carefully and think of the best answer choice for sure. For you know, wills and trusts, if I were to be a guessing person, I think it's the most likely to not be tested this administration. But again, it could very well be tested. Don't call me out on that. I mean, I'm not a gambling man. I'm a hard ass worker. And then What about business entities? Business entities, they're going to test partnerships and corporations extensively. Partnerships, think about the difference between a general partner and a limited partner. General partners are people who have unlimited liability, whereas limited partners have limited liability. So a general partner could be personally liable, whereas a limited partner will only be liable to the extent of their investment. We have a partnership if people, join together to share a profit, right? It doesn't need to have a written partnership agreement, although it should. Whereas anything above a GP, like an LP or an LLP or an LLC or a corporation, they need to have formal documents filed to create that entity. Understand the concepts of actual authority. So it can be implied or express authority, apparent authority, meaning that a third party would think that you have authority, or inherent authority, meaning like it's inherent to your job duties. Typically, it's going to be binding. If you are stuck and be like, will they be able to bind the partnership with this decision? As long as it's within the scope of business and it's not outrageous, they're going to be able to bind them typically. So yeah, make sure you can understand the differences between general partners where they're all unlimited liability versus limited partners like an LP. An LP has to have a GP and an LP, and the LP has limited liability. The GP has management responsibilities. An LLP would have only limited partners. An LLC is an election to be treated like a corporation where you'll have limited liability and flow through taxation. Um, duties of loyalty, duties of care, duty not to commingle, buy property. It's going to be assumed to be part of the partnership. Profits and losses are going to be assumed to be shared equally unless they're otherwise in a partnership agreement. Corporations, much tougher. They'll test the piercing the corporate veil where they have to show an improper purpose, something like alter ego or commingling or inadequate capitalization. And that would allow them to pierce the corporate veil and go after the shareholders directly or the parent company of a subsidiary company. They test the business judgment rule, meaning that, like, a director, as long as he made a decision that was reasonable, he won't be judged to have violated a duty based on the outcome of it. He'll be protected under the business judgment rule. Remember, C corporations have limited liability and double taxation, whereas S corps, LLCs, LPs, LLPs, they have flow through taxation and limited liability. Remember, common shareholders, common stockholders have the right to vote on stock splits, on mergers, acquisitions, liquidation events, obviously voting for members of the board of directors. These are changes to the articles of incorporation. Those are fundamental changes that common shareholders have the right to vote on. Preferred shareholders have liquidation priority over common shareholders and dividend priority when declared. Um, Remember cumulative voting they like to test. Cumulative voting allows shareholders to pool their votes together for a single chair. So if there's two chairs open and you have 100 votes, you could vote 200 shares for chair one. Where if there's two chairs open and you have 100 shares and it's statutory voting, you would have to allocate 100 votes to chair one and 100 votes to chair two equally. But cumulative allows you to pool your votes together, and it benefits minority shareholders because it gives them the opportunity to all pool together and vote for a chair on the board of directors. Remember that the board of directors serves at the pleasure of the shareholders, and the officers serve at the pleasure of the board of directors. One thing that I saw tested in wills and trusts, they test this all the time, is that no contest clauses are not enforceable. You can't enforce a no contest clause. For corporations, the board of directors, absent agreement otherwise, they can set their own salaries. That's something that I've seen them test before and heard them test before, and you want to be able to get that question right. Um, typically you're going to need a majority vote from the shareholders. If they mention blue sky laws, that's about intrastate securities and about the requirements for when, securities are going to be sold only within a state. If it's interstate, it would be the Act of 1933, which would uh, be about the Paper Act and the Prospective Act and things like that. You see something real quick. Yeah, okay. Sorry. Act of 1933. Okay, so that's like, there has to be prospectus, there has to be fair disclosure and all that. They test the tipper and tip B thing where like, anyone 10b5 can be held liable if they have insider information and they act upon it. I mean, corporations is a monster subject and partnerships are monster subjects. And, I definitely would review them because I think it could be tested. Secure transactions and commercial paper simple, right? Don't spend your last 3 days studying those subjects intently. Just know the basics. Commercial paper, it's a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order bearer with no additional undertakings. A draft is a three-party instrument. A note is a two-party instrument. If it's conditional, it's not commercial paper. To negotiate bearer paper, it's just transfer of possession. To negotiate order paper, it's transfer of possession plus endorsement. A holder in due course is someone who takes for value in good faith without notice, and they're subject to the real defenses but free of the personal defenses. Those are the main things that you need to know about with commercial paper, Article 3, signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definite time to order bearer with no undertakings. Secure transactions, Article 9, is more about collateral and different types of collateral, where there'll be, you know, uh, consumer goods, inventory, equipment, and farm products. You attach via security agreement. You perfect via financing statement, unless it can be ownership or control. And the security agreement needs to sufficiently describe the collateral, whereas the financing statement can be more generic in its description. So they'll test that a little. A PMSI, a purchase money security interest, very much like a PMM, where the money borrowed is used to purchase the collateral, and that'll have super priority because there's automatic perfection upon attachment in consumer goods, and there's a 20-day grace period for perfection upon attachment in non-consumer goods. We talked about tangible collateral. There's also intangible collaterals like accounts receivable, promissory notes, and things like that. They can typically attach and perfect via ownership or control. But the main way to attach is security agreement. The main way to perfect is financing statement. And then when you look at priority, it's first in time, first in right. If it's perfected versus perfected or attached versus attached, except the PMSI will have super priority. And then obviously a perfected will have priority over an unperfected, and an attached will have priority over a non-attached. And then if you're trying to recover the collateral, you can do it so long as you do not breach the peace. And like I said earlier, in contracts, you would need to seek a writ of replevin in order to recover collateral that you couldn't otherwise recover without breaching the peace. So I know that people love to freak out about secure transactions and commercial paper. I'm here to tell you not to do it because think about it. If it's tested, 30 questions, and it's wrapped up with commercial um, corporations and partnerships, mathematically, you would expect 10 questions on corporations, 10 questions on partnerships, 5 questions on commercial paper, and 5 on secured transactions. And I feel like it would be skewed even differently. I feel like it would be like 23 questions on partnerships and corporations and 7 on secure transactions and commercial paper. So are you really going to freak out over 7 questions that could potentially be tested? Not really. If they test 7 questions, they're going to be easy 7 questions. I would go more into corporations and partnerships. Partnerships is a little bit more intuitive. Corporations is tough. I think that's a subject that, wills and corporations, I would kind of go into the nitty gritty and really be able to understand and answer those questions. Evidence is an interesting one because if evidence is tested, it's going to be 30 evidence questions. It's the only subject that comes on its own. Where if it's wills and trust, it'll be split. If it's business entities, commercial papers, secure transactions, it's split into 4 subjects, right? If it will be procedure, that's split into 3: judicial, civil, and criminal. But if evidence is tested, which I think it will be tested, you're going to get 30 evidence questions. So it's a test, it's a subject that could really, you'll take it and be, wow, there are a lot of evidence questions. Yeah, mathematically there should be, right? So, evidence, it's federal code with distinctions. So I think that probably one of the best resources that we have is this resource that Danny made for federal versus Florida evidence distinctions. And if it were me, down the stretch, I would put my nose into this worksheet and I would, learn from it. So, just to pull it up so you guys can see how pretty it is. Um, and by the way, Danny is a superstar. She's a former tennis player. Now I think she does racquetball or something or paddle or something, but she's a superstar. She was my LSAT student and my bar student now working with us. I have so much love for Danny. She's awesome. So these are the Florida rules, right? Like if you go over this entire chart, remember judicial notice, right? If judicial notice is given, they may but are not required to accept it as conclusive in Florida. It's mandatory. Um, a lot of things about judicial notice. Remember, huge thing in Florida, rep, yep, op, nope, meaning we do not allow testimony for character evidence, only reputation testimony. So that's a big distinction. Reputation is allowable, but not opinion testimony. There's yeah, right here, reputation only can come in. Um, the privileges that are recommended that are recognized in Florida: attorney-client, fiduciary lawyer-client, psychotherapist, sexual assault counselor victim, domestic violence advocate victim, human trafficking victim advocate victim, marital communications, clergy, accountant, journalist, trade secrets, and accident report privileges. You see, neither in Florida or federal do we have a uh, physician-client privilege. But also in Florida, you'll probably notice that there's not a spousal immunity, only marital communication. So you don't have that right not to testify against your spouse in a criminal case in Florida. You only have the marital communications privilege where you can prevent your, marital communications from being admissible, but not if you're adverse to each other. If the husband's suing the wife, then that privilege would not exist. Um, so yeah, a lot of good things on privileges on this sheet. I think it's a really, really good sheet to like go over. Um, they test a lot about the difference between a party opponent admission and a statement against interest. Remember, statement against interest requires the unavailability of the declarant, where a party opponent admission is a party or a party opponent. So an agent, a co-conspirator, an employee, or a plaintiff or defendant, someone who's a party that a statement is being used against them. Um, right? Admissions are exceptions to hearsay, not non-hearsay. So Florida doesn't have hearsay exemptions. It just has hearsay exceptions. And right, these are the ones where unavailability is required. Okay, another distinction. Dying declarations in Florida are admissible in all cases, civil and criminal. And federal, they're only in civil and homicide cases. So that's a good distinction to remember. Um, yeah, a lot of cool stuff here. Another big distinction would be let's see, she has it. The learned treatise doctrine, right? Florida does not recognize the learned treatise doctrine where it can't come into evidence. It can only be used for impeachment and cross-examination if the expert recognizes or a judge finds the source authoritative or relevant. So there's no learned treatise exception in Florida. It can only come in for impeachment, but it can't come in substantively. Florida does have this child victim thing. So admissible for victims 16 or under, describing abuse if reliable, the child testifies or is unavailable with corroboration, right? So, and then there's also one for elderly and disabled persons. Similar child victims requires unavailability, reliability hearing, corroboration, and a 10-day notice. So Florida has these additional child victim and elderly or disabled person hearsay exceptions. Other than that, other than the things that are included on this chart, I mean, it's pretty much the same rules as federal when we're talking about evidence, right? Evidence needs to be reliable and needs to be relevant, right? It has to have some tendency to prove or disprove a controverted fact. Hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. There's a bunch of hearsay exceptions, some which require unavailability and some which unavailability is immaterial. I think in Florida, you think of a habit as an individual and routine as with a business. Um, I'm trying to think about evidence questions, but we still have the mimic rule, right? It can come in from motive, intent, mistake, lack of mistake. Um, identity, common scheme, or plan, right? That's when you can use prior bad acts to, you know, impeach a witness. Florida has a different rule when it comes to impeaching with a conviction over 10 years. It's not that it doesn't come in. It's just that the judge has discretion if it's too remote in time to have any bearing on the case, but it's not a strict 10-year rule. So, evidence is a tough thing to teach the main points because there's so many things that could be tested, but remember that like questions of admissibility are for the judge, not the jury. The weight of the evidence is for the jury. Florida, just like federal, recognizes the Daubert standard for qualifying an expert witness, so it has to have um, special technical and scientific reliability and be the judge is the gatekeeper of whether an expert can be qualified or not. Again, I think the evidence is a really tough subject, and I would encourage y'all to study it down the stretch. For criminal procedure, criminal procedure, again, tough subject. Procedure is the most important subject for y'all to study. It's guaranteed to be tested. So definitely know like the speedy trial rules, know the first appearance, the arraignment, things like that. So first appearance is within 24 hours. The non-adversarial probable cause determination hearing is within 48 hours with two 24-hour extensions, so a possibility of up to 96 hours. The adversarial probable cause determination hearing would be for someone charged with a felony who's either in custody or have had significant restraints on their liberty, and that's within 21 days. The you know, they can hold them. It's the 30, 33, 40 rule without filing charges. So they within 30 days, they have to release them on the 33rd unless they can get extension for the 40th day. So those are all good dates and times to learn these things. So the 24-hour rule, the 48 plus 2 24-hour extension rule, the 21-day rule, the 30, 33, 40 rule. And notice that they've changed the speedy trial. So it's not from the date where of the arrest, but it's from the date when charges are filed. So if they make a demand, it's from 60 days. If no demand is made, then it's 90 days for a misdemeanor, 175 for a felony. And if it's a felony and a misdemeanor, you'll get the longer of the two, so you get the 175 days. And now they've changed the recapture period to be 30 days instead of 10 days. Um, for Florida criminal procedure, they'll test all that stuff about like your rights when you're arrested and when you're being held and when charges are being filed and your right to a speedy trial. They'll also test like how many jurors you get, right? Like it's 10 for a capital, 6 for a felony, um, 3 for a misdemeanor. Um, I'm sorry, I think that's how many peremptory challenges you get versus how many yeah, that's what I'm talking about, how many challenges you get, peremptory versus for cause challenge. You get unlimited for cause challenges, and then you get peremptory challenges, 3 for misdemeanor, 6 for felony, 10 for capital case. The voir dire and the venire and all these different things where we're concerned with what the jury pool is going to look like and what's necessary for a conviction. These are all important things. And then what types of cases go to the Supreme Court versus what go to the lower levels. Criminal procedure, it's tough. It could be a lot of different things that are tested, but I would definitely make sure that you understand like the speedy trial, the arraignment, the first appearance, and things like that. Remember, the arraignment is where you're going to plead guilty or not guilty or whatever it may be. Again, I would go over the practice questions for criminal procedure. If it were me and I was like, what topics would I go over a lot down the stretch? It would be criminal and civil procedure. Um, Civil procedure is tough, but it's a lot like federal law. A lot of the same concepts about SMJ, PJ, and venue. Remember, you can bring uh, motion to dismiss for SMJ at any time. Um, a lot of standards for summary judgment and directed verdict and belated directed verdict. The time periods change a little bit from federal to Florida. So Florida, it's 15 days for a new trial or for a renewed or belated directed verdict. See, this whole concept of like directed verdict, JMOL, they're pretty much the same thing. Renewed, belated. You have to bring it up. And then you can move for the directed verdict after the opposing party has presented evidence. And then you can move for a renewed or belated after the verdict, so long as you brought up the original one. And then an appeal is 30 days. There's a year for relief from judgment for certain things like, newly discovered evidence or fraud by an opposing party. And then sometimes you can bring up, relief from judgment at any reasonable time if it's for like a clerical error or fraud on the court or something of that nature. Um, Judgment on the pleadings is after the complaint and the answer, or if there's a counterclaim, the answer to the counterclaim. The standard for summary judgment is no genuine disputed material facts. The standard for a directed verdict is that no reasonable juror could find in favor of the non-moving party, or there's sufficient evidence in favor of the moving party. Um, you know, if there's a new trial, it would be granted because the verdict is against the weight of the evidence, or there's juror misconduct, or there's you know, something that affected a plain error that affected their substantial rights. Um, Legal issues are reviewed de novo. Um, uh, Admission issues are abuse of discretion, and findings of fact are for the clearly erroneous standard. Um, Florida civil procedure and criminal procedure, we have some really good resources in the classroom that I would recommend you use. Even before Danny, I had a student named Hannah who made some really great outlines for us, and they're super colorful for civil and criminal procedure. And these are things I look at, down the stretch. Like, let's see what we got here. Yeah, I think this is a outline that, well, that one might not open. Um, this is the outline that, okay, this is the outline that Danny made, right? So 120 days for service compared to 90 days. A lot of 20 days for how long you have to answer things in Florida civil procedure, like 20 days to answer the complaint, 20 days to amend the complaint, 20 days to answer the pleading, the counterclaims, the cross claims. Remember, counterclaims are against the V, cross claims are on the same side of the V. When you're super in doubt, it seems like 20 days is pretty proper for a lot of things when it comes to civil procedure. You get 30 interrogatories um, and 30 days for request from production. Um, Jury demand, so 10 days after the last pleading directed on the issue instead of 14 in federal, right? Um, just some distinctions. Like I said, the 15 days for the renewed directed verdict or the belated directed verdict, and 15 days for the new trial, 30 days for the appeal. Um, yeah, those are some really good things from civil procedure that you can memorize. And then for criminal procedure, let's see. Yeah, these are the sheets that I was talking about that Hannah made for us. I'm sure you can open it somehow, but those are the sheets that Hannah made. They're super colorful. These are like the original dates and timing sheets that I had made uh, originally, but I think that Danny did a way better job of making it beautiful and things like that. So remember some of the things that we talked about, the 30, 33, 40 rule for filing charges, the speedy trial, right? 90 days from when the charges are filed for misdemeanors, 175 days for the felony. Um, Alibi defense has to be within 10 days of 10 days before the trial. Insanity defense no later than 15 days after the arraignment. Um, Yeah, a lot of really good stuff on the dates and times here. So like these dates and times sheets that Danny made, I think are some of the key things that I would study down the stretch. And then the last thing I guess would be judicial procedure. I think what they usually test is that, a judge can be disqualified if he's impartial or is related to someone in the case within the third degree. like a cousin or a brother to an attorney or a witness or something like that. So it's usually about judicial disqualification. Um, my recommendation when it comes to Florida multiple choice is, like I said, do these FBE questions over and over and over again, get 100% on them. And then I think that um, these fundamental questions that I've created. These are brand new for this administration, but I would probably go over them like the 15 question civil procedure fundamental review, right? You want to be able to get 100% on all of these because these are brand new and updated and they're very fundamental. If there's a subject that, you're not really clear about, then, maybe go ahead and do the entire 50 question review again. But I think just as a matter of course, doing the 15 to 10 question fundamental reviews will be really nice. And then definitely doing the FBBE practice questions. That's the number one place that I would go to would be the FBBE practice questions. So, I'll end with the same advice I started with, is that the best resources that you can use as the test is coming near are the FBBE practice questions. You should be getting 100% on them as a matter of course. And then my essay guidebook, just reading over, some areas that you might be gray or fuzzy on. And then, down the stretch, how can you really push the uh, envelope and put yourself, over the top, I think is dates and times. Like I don't do much teaching of that during the course because, you'll forget it 4 weeks ago. But now's the time to memorize it cold. And if you can just get some questions right on test day because you remembered 20 days or 30, 33, 40 days, or, you can remember those dates and times and the evidence distinctions, that's really, really helpful. Okay, so just some questions. Uh, so you're talking about surcharge, right? Surcharge for an easement, like it's getting monetary relief for it. Like you're not going to terminate the easement, but you could get injunctive relief for them to stop overusing it, and you could get a surcharge. Like if they were only allowed to use the pond for recreational purposes, and now they're doing a little boat tour and they're charging people to do the boat tour, you could charge them a surcharge, and they would have to pay you the money that you made. Um, a hearing on termination of parental rights, yeah, you can't just terminate parental rights. They would have to be something that a judge would say. Mistake is a valid defense to specific intent crimes, right? Also, voluntary intoxication is not a defense to specific intent crimes. Yeah. Specific intent, you need to have the specific intent to do it. So, a mistake, like you thought you were doing something else, wouldn't be valid. If you thought you were recovering your purse, but it was really not your purse, that's not going to be larceny because you didn't have the specific intent for thievery. And then voluntary intoxication, typically not. Like if I'm going to kill Susie and then I stop at the bar and get drunk to calm my nerves, that's not going to be a valid defense. Now, if I'm just sitting on my couch and someone gives me and says, "Hey, take this Jolly Rancher," but it's actually like some bath salt type thing, and then I go bite someone's head off, that would probably be a defense because I was involuntarily intoxicated. Um, so there's a client summary of rights in Florida where they can back out free of charges within 3 days. Um, I believe so. I'm not exactly sure what you mean by that. Resulting versus constructive means that like they're both court ordered, but resulting is pretty much when a trust fails and we're going to have some leftover and we're going to just put that into a trust. A constructive trust is more when, the court just determines we should create a trust in the nature of equity. So resulting is kind of like the leftovers from a trust, where constructive is when a court creates a trust. Um, Trust is definitely not an essay topic. But again, they could be a trust issue. There could be a will issue. Like there was a test recently where they wanted to ask about the Simultaneous Death Act on an essay subject. Even though wills is now supposed to be an essay subject, they could ask about the Simultaneous Death Act or something where you presume that if they died at the exact same time, they survived each other. Florida does not recognize the 120-hour rule where you need to survive them by more than 120 hours. If you survive them by 2 minutes, then you survive them and that's how the estate will devise. But if you die at the exact same time, then the presumption will be that you survived each other, and that's how it will go. Um, yeah, no trust essays. Yeah. I don't know when I said if you get a trust essay. There's no trust essays. It's only multiple choice. Withdrawn guilty pleas are not admissible, but all guilty pleas are. Yeah, I would say that guilty pleas are admissible because it's a plea, but plea bargaining is not going to be admissible for evidence. Typically, there'll be like a question where there's a statement for medical diagnosis or there's a statement for offering to pay medical expenses, that can be bifurcated where the medical statement will not be admissible. Like if it's saying, I feel so sorry about this, so I'll pay your hospital bills. The statement, I'll pay your hospital bills is not going to be admitted. But the statement where I'll pay your medical expenses, that could come in because it can be bifurcated. If it's like to compromise, oh, well, you were wearing high heels and I might have left some water on the floor, then the entire statement is not coming in because it's a statement of compromise. But a statement for paying medical expenses could be bifurcated where the admission statement would come in. If it's a statement for medical diagnosis and it says like Tommy shot me and then stole my chain, the statement where Tommy shot me comes in because that's for medical diagnosis. The statement where he stole my chain would not come in because it's not for medical purposes. Um, can we see the evidence tested on the essays as a subtopic? I mean, yes, you can. It could be procedure, it could be evidence, it could be trust, it could be wills, it could be commercial paper, secured transactions. They could be tested on essay subjects. If you read the fine print of the Florida announcements, they say that those subjects are tested primarily as multiple choice subjects, which leaves the door open for inclusion on an essay subject. So, if you see, holy shit, this is a spendthrift provision, you should write about a spendthrift provision on the exam. Um, okay, so, um, all right. Bail is addressed at the first appearance, not arraignment. I like that. Arraignment is where you enter your plea, right? Okay, amazing. And then Joe said, uh, can you send the link, please? What do you want the link for, Joe? Not exactly sure. But otherwise, for Dane's distinctions. Okay. So um do you have access to the Google Classroom? Everyone here should have access to the Google Classroom. Here's the class. I'm gonna include the link right now to the Google Classroom, and then just go to the classwork, and then go to by subject, and you could see it. And then Lisette actually included it as well. So everything you need is in there and more. I'll leave you all with some final pieces of advice, which is you're passing this test, right? Don't tell yourself anything otherwise. You're passing this test. Even if you didn't do absolutely shit until now, but you listened to my lecture and you have my essay guidebook and you have the Florida multiple choice Q bank to practice, you could pass this test. I know that people, and I'm one of them, who spend so long telling you the Florida bar exam is the hardest test. It's so hard, it's so hard. But I kind of lie to you guys. It's not that hard. It's a very passable test. Mostly all my students pass this test with flying colors. I know hundreds of thousands of people, hundreds or thousands of people who have passed this test with way less than what you've received. I mean, just with Danny's new distinctions charts, those are way better than what people had when I took it. In 2017, I took this test, and most of my friends were 2016 because I did a 4-year program. But my friends, James and Tim and Zaylin and Ryan, they passed this test, and they are not geniuses. I don't care if they heard me say that. They are not geniuses. They're not very studious. They're not like great test takers, and they passed this test. And I was just like, if they can pass this test, anyone can pass this test. And the resources they use to study were nothing compared to the resources that I've given y'all to study. So you guys have everything you need to pass, and it's very passable. I know that some of you haven't passed in the past, but that has absolutely nothing to do with the test that's in front of you. It's a brand new day. And, just like in evidence, we're not going to bring in, prior acts of running red lights to show that you ran the red light today. We're not going to care about how you scored on the last test when it comes to this test today. This is a brand new opportunity. You know what's in front of you. I've given you every single resource that you need. And, just don't overthink it. When the essays are given to you, just start writing, write your ass off and try to get all the points. And for the multiple choice section, just don't psych yourself out. Just be calm and confident in the answers that you choose. And you don't need a 94% to pass Florida multiple choice. It's a very passable test if you just get the majority of the questions right. So I really believe in positive thinking and manifesting your results. I believe that every single person in this room is going to pass. And I don't think you're just going to barely pass. I think you're going to pass with plenty of room to spare. So be confident in yourself. I really believe that every one of you is going to pass this test, but don't minimize the exam. Go in there professionally, cash the check, and then I'll see you on Wednesday night to have a celebratory drink, or just to talk and shoot the shit with y'all a little bit. I really really enjoy everyone in this class. I think this has been my most respectful class ever. Usually I have some people who are disrespectful to me as a professor and to my team as a business, but everyone here has been super respectful, and I really appreciate the hard work. Hard work pays off, and I'm expecting you all to pass this test. So I will see every one of you in Tampa. If you see me, don't be shy, say hello, but also, don't lose focus. Stay focused on what's in front of you. Knock this thing out of the park, and have a really great test taking experience. If you're taking the MBE the next day, once the test ends, you got to shake it off and put yourself in position to pass the MBE, which is a totally different test. But for the Florida bar exam, it's coming up on Tuesday. I would spend today and tomorrow studying, finalizing dates and times, and going over the essay guidebook, going over the FBBE practice questions. But don't have a crash out or a mental breakdown or freak out now, right? You're right there. And if you just listen to this lecture, I gave you mostly everything you need to pass, and you still have time to double down, triple down, and get to where you need to be. So be confident in yourself. Know that I'm confident in all of you. Thank you all so much for joining me, and I'm really wishing you all the best of luck on your exam.